If you have a case pending with USCIS right now, stop what you are doing and watch this video. Processing delays in 2026 are not just an inconvenience anymore. They are affecting people's jobs, their families, and their ability to stay in the United States legally. And the situation right now is getting worse, not better. Welcome back to Immigration Updates today. I am glad you are here because this is one of the most important updates we have covered this year. Today, we are talking about USCIS processing delays in 2026. What is causing them? Which visa and green card categories are hit the hardest? And most importantly, what you can do right now to protect your case. This is not old news. This is happening this week, this month, right now in April 2026. And if you or someone you know has a petition or application pending, this video could save you from making a very costly mistake. Let us get into it. The scale of the problem. A record backlog. Let us start with the numbers, because the numbers are alarming. As of early 2026, USCIS is managing a record backlog that has surpassed 5 million pending cases. Some reports from earlier this year put that number even higher, past 11 million pending cases, when all form types are counted together. Every year, USCIS processes roughly 10 million applications, petitions, and requests. But as the volume of new filings continues to outpace the number of completions, the backlog keeps growing. And here's a detail that many applicants do not know. At the end of 2025, USCIS had a front log of around 250,000 unopened petitions. These are applications that had not even been looked at yet. Not delayed, unopened. This backlog is real, it is documented, and it is affecting almost every category of immigration benefit right now. Staffing cuts are making it worse. Now let us talk about why this is getting worse in 2026. And this is something you need to understand clearly. Since the start of 2025, the federal government began large-scale workforce reduction efforts across multiple agencies, including the Department of Homeland Security and USCIS itself. Reports indicated that up to 20,000 USCIS employees were asked to take early retirement, accept voluntary separation payments, or face layoffs. On February 14, 2025, DHS terminated nearly 50 USCIS employees directly, identifying them as non-mission critical personnel. Those workforce reductions from 2025 are still affecting case processing today in 2026. Here is the important thing to understand. USCIS is primarily funded by filing fees, not by government appropriations. That means even during a partial government shutdown, USCIS continues to process applications, but with fewer staff members doing the same amount of work, cases move slower, much slower. The American Immigration Council put it plainly. With fewer personnel, USCIS will struggle to manage its caseload efficiently, and that results in longer wait times for applicants. The January 2026 policy hold, who is frozen. This next part is extremely important, especially if you are from a country that has been designated as high risk. On January 1, 2026, USCIS issued Policy Memorandum PM 602-194. Under this memorandum, USCIS placed a hold on the final adjudication of all pending immigration benefit requests filed by or on behalf of individuals connected to countries designated as high risk under Presidential Proclamations 10949 and 10998. What does that mean in plain language? It means your application can go through all the steps, all the paperwork, all the biometrics, all the reviews, and then simply stop right before a final decision is made. The application is paused at the finish line. This hold applies to a wide range of applications, including Form I-129 for work visas, Form I-140 for employment-based green cards, Form I-539 for change of status, and Form I-765 for employment authorization. USCIS has acknowledged that this will cause processing delays, but the agency says these holds are necessary for national security reasons. The hold remains in place until USCIS leadership officially lifts or modifies it. If you are from an affected country, you may be waiting months with no end date in sight. Even cases that are fully approvable may not receive a decision. Which forms are being delayed the most? Let us look at current processing times because this is what people need to know right now. For family-based cases, Form I-130 is one of the most affected. If you are a green card holder petitioning for a spouse or child, wait times can reach up to 35 months. That is nearly 3 years. These are real families being kept apart. For Form I-485, which is the adjustment of status form used to get a green card inside the United States, processing times in employment-based categories currently range from 11 months to over 31 months, depending on your service center and visa category. For work authorization, Form I-765 delays are especially damaging. If your employment authorization document is delayed, you could lose your job. You may not be able to accept new employment. This is a serious real-world consequence. For perm labor certifications, which are required before many employment-based green card applications can even begin, wait times have been adding more than 16 months to the overall timeline. That means the clock starts ticking long before USCIS even receives your green card application. For naturalization, there is actually some better news. Form N-400, the citizenship application, is processing faster than it has in years. The national median sits at around 5 to 7 months. That said, applicants from certain countries affected by the January 2026 policy memo may face significantly longer waits or indefinite delays. What could happen? If you ignore these delays, do not assume that slow processing means your case is fine. There are real risks to being unprepared. If your work permit expires and your renewal is delayed, you could have a gap in employment authorization. That could mean losing your job and losing your income. If your advance parole travel document has not been approved and you leave the United States, you could abandon your green card application entirely. Do not travel without checking your documents first. If USCIS sends you a request for evidence, called an RFE, and you miss the deadline, your case could be denied. These responses have strict deadlines, and in this environment, there is little room for error. And if your case falls under the January 2026 policy hold, approved benefits from after January 20th, 2021 may even be reopened for review. That means USCIS could request additional documentation or schedule new interviews for cases that were already approved. Practical guidance. What you should do. Right now. Here is your action plan. Do these things today. First, check your specific processing times on the official USCIS website using their processing times tool. This tool is updated weekly. Enter your form type and service center to see where your case stands. If your receipt date is older than the posted processing time, you have the right to submit a case inquiry through the USCIS website. Second, create a USCIS online account if you have not already. This allows you to receive instant updates, view your notices as PDFs, and respond to requests for evidence digitally. It is free, and it saves time. Third, if you receive a request for evidence, respond as quickly and completely as possible. Do not wait. Delayed responses extend your timeline even further and can lead to denial. Fourth, if you have an employment-based petition like an I-129 or I-140, check whether premium processing is available for your category. As of March 1st, 2026, the premium processing fee is up to $2,165, depending on your form type. It guarantees a response in 15 calendar days. It does not guarantee approval, but it does guarantee a decision. Fifth, if your case has been pending for an unusually long time with no movement, consider contacting your local congressional representative's office. This is a legitimate option. Congressional inquiries can sometimes prompt USCIS to prioritize a case. Sixth, as a last resort for severely delayed cases, some applicants have pursued a mandamus lawsuit in federal court. This compels USCIS to make a decision. Costs typically range from $3,000 to $8,000 in legal and court filing fees. This is not for everyone, but it is a real option that has worked for many applicants. Let us quickly summarize what we covered today. USCIS is managing a record backlog in 2026, with millions of cases pending and processing times stretched across nearly every form type. Workforce reductions that began in 2025 are continuing to slow processing at service centers and field offices across the country. A new policy memorandum from January 2026 has placed a hold on final decisions for applicants from high-risk countries, affecting work visas, green cards, status changes, and employment authorization. Family-based petitions face waits of up to 35 months. Employment-based adjustment of status cases range from 11 to over 31 months. Work permit delays are causing employment gaps for real people right now, and if you do nothing, your situation could get worse. Missed RFE deadlines, expired documents, and unanticipated holds can derail even strong, complete applications. This is why staying informed matters, not just for yourself, but for your family, your employer, and your future in this country. If this video helped you understand what is happening with USCIS right now, please take a second and give it a like. It helps more people in your situation find this information when they need it most. Share this video with someone who has a case pending. They need to know this. And subscribe to Immigration Updates today so you never miss a critical update. We cover the real changes, the real timelines, and the real actions you need to take every week. Thank you for watching. Stay informed, stay prepared, and we will see you in the next one.